So what types of discovery are there? There are four major types of discovery. One is a deposition. Two, interrogatories. Three, request for admissions. And lastly, document productions. All right, so let's go through each of these quickly. Again, you may know these, but we want to give you an overview just in case you may not know exactly what these things are. All right, so a deposition. What's a deposition? A deposition is a question-answer session between a party's attorney and any person the attorney feels has information that is relevant to the case. This session takes place in a conference room, much like what we're in now, without the presence of a judge, and is recorded word for word by a reporter. The court reporter is present throughout the entire session and will produce a transcript that will later be produced. The transcript may become e-discovery, and we'll talk about that more later. Secondly, we have interrogatories. What are interrogatories? Interrogatories are specific questions, written questions, submitted by a person who must respond under oath and in writing. Interrogatories must state questions in a precise manner so as to elicit an answer that is pertinent to the issues being litigated. And there's usually a specific amount of number interrogatories that's allowed, maybe 33 questions that can be provided to the person who is required to answer these questions. Third, request for admissions. And these are basic, simple questions where the person just says admit or deny. And these are fact statements that are given to the party in order to elicit the just the facts of certain, the authenticity of facts within the case. Then lastly, we have a request for documents. And this is where the meat of the e-discovery comes in. So what's a request for documents? The request for documents is just that. It's when during the discovery phase, a party to a lawsuit may request that another party provide or literally hand over any documents that are pertinent to the subject matter of the lawsuit. So what does that mean? So basically, if you have two people who are suing each other, one person, person A, makes a request to the other person to produce all the documents they have on a particular subject. These documents could be email, they can be files, they can be anything that's stored on the computer. It's requesting all the documents that the other person has. And this is to ensure that only the appropriate information is given to the other party. Attorneys review the documents their clients provide in response to a request for production of documents before forwarding them to the party that's making the request. Alrighty, so that's the four types of discovery tools. The last one, the request for documents, that's the majority of where your e-discovery is going to come from.